Right, we are back on the record on JU 8801. All parties are present with counsel, and we now have Ms. Martin on the stand. So if you will raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, be sure you speak up because we're recording this.
You state your name for the record, please.
Alex Martin,
And Ms. Martin, where are you employed?
Cleburne County DHR.
And what do you do there?
I'm a social worker.
And are you familiar with the Holm case?
I am?
And is it because it's assigned to you?
Yes.
Can you tell us when you became associated with this case?
Yes, October 12th.
Okay. And can you tell us, I guess, what you've done on this case since then?
I've provided service to the family.
Okay. And specifically, let's go back to October then. Can you tell us how you began providing services to the family?
Yes, we did an ISP, an initial ISP. We started supervised visitation at the department 3 times a week.
I'm sorry.
Making sure you're going to have to speak up, okay?
Oh, I
Mr. Kirby's a
apologize.
little hard of
Oh.
hearing, and so am I. That's probably will help.
Oh, I apologize. I felt like I was screaming.
Probably help if you turned your seat more that way so you project this way into the room. How's that? Okay, there you go. Okay, go ahead.
All
Sorry.
right. So you were in the middle of your answer. So you started
yes,
supervising
Mr.
visits 3 times a
Holmes,
week.
Yes. Supervised visitation 3 times a week, Monday, Wednesday, Friday, from 9 to 12. Sometimes I'd allow those visits to go until 1 to allow breastfeeding. We'd also provide assistance with transportation. At the beginning, I transported Mr. and Ms. Hall and myself from Chia Hall to the department. And then after they got their vehicle, we provided gas vouchers as well.
Okay. What other support did you provide to them?
Also for them to complete a psychological evaluation.
Okay.
And also for them to do an intake at mental health.
Okay. All right, so let's talk about the supervised visitations. Did those begin?
Yes.
Okay, and did those begin shortly after the ISP?
Yes.
Okay. And can you tell us about the visits?
Yes. Mr. and Ms. Holm, during the visitation, Mr. Holm would excuse himself 30 minutes into the visit to either go to the restroom, and after he would use the restroom, he would either go outside of the department to speak on his cell phone. He would tell me that that was so he could speak to people about the case, for him to get help. Then he would return back into the visit. I have not observed Mr. Holm holding the baby. During one visitation, Ms. Holm asked Mr. Holm if he would like to hold the baby, and he stated he did not, that the baby needed her energy and not his.
Objection. Is it hearsay? No. What?
Judge, it's a party opponent admission. Statement by a party opponent.
She's running on a narrative and not asking questions.
If you would just
Yes.
answer the question as best you can without giving a narrative to it. Okay.
Just answer a few sentences, and then I'll ask you another question. Okay?
Yes, sir.
All right. So, during the visitations, did Mr. Holm interact with you?
No, not during the visitations.
Before or after would he interact with you?
Yes.
Did anything peculiar happen during those times?
The only incident I can recall is after one visit, he stated to me that Hillary Clinton did not win the presidential election, and that's a good thing because she supported organizations like CPS, and people such as my supervisor, Leslie Smith, should not be receiving raises for what she does, such as kidnapping children.
Did you ever hear Mr. Holm refer to anyone as a devil?
Yes.
Okay, and specifically, do you know who he's referring to that?
I cannot recall.
Okay. Was it anyone at the department?
Yes.
And during those visits, can you tell us what Mrs. Holm's interaction was with the child?
Yes, Miss Holm would breastfeed the baby. She would hold the baby. As the baby would take naps, she would take a nap with the baby. And they would rest.
Would Mr. Holm be saying anything during the visits to Ms. Holm?
Yes, Mr. Holm would speak about the case, and he would speak about his beliefs to Mrs. Holm.
During the entire visit?
Yes.
Is that a bit peculiar?
To me it is, yes.
I'm sorry, I didn't hear the question. Well,
The question was,
never mind, Mr. Holmes.
and did there come a time where the visitation stopped?
Yes.
Okay, and approximately when was that?
It was November 14th.
And can you tell us why?
The department was contacted by Mr. and Ms. Holm stating that they had business to handle and they did not feel safe at the department.
Okay. After that visit, did the department receive any documents in the mail?
Yes, we received a 30-plus page document.
Okay. As a result of that, did the department have concerns for safety?
We did.
Following the receiving of that document, was there any other conversations with the Holms regarding visitation?
Yes, Mr. and Ms. Holm contacted the department on November 16th.
And what happened on that conversation?
They stated that they wanted to visit at the department, but due to what was mentioned in the document, the department did not feel safe either. So,
during that time, did the department receive any mental health records with regards to the father?
yes.
And can you tell us what, if any, concerns that caused for the agency?
It showed that he has
Objection. Objection, hearsay.
Mr. Schlinker.
Judge, it is not asking for hearsay. While the answer itself may elicit hearsay from the witness, then it would be appropriate only after she has made a hearsay statement.
At this point, your objection is a bit premature, but go ahead, Mr. Slinker.
Not what is
Double
contained.
standard.
Not telling us what's in the record, but with regards to records that the department received. Can you tell us what the department received?
mental health records.
Okay. With regards to who?
Mr. Holm.
Based on that, did the department have concerns with regards to the parents visiting?
Yes.
Subsequent to November 16th, when is the next contact that you had with the parents?
Last Friday.
I'm sorry, when?
Last Friday.
Do you have any contact with them at the first trial setting?
Yes.
Okay. Did y'all talk about anything at that point?
No.
Okay. Or nothing substantive?
Right.
You exchanged some pleasantries?
Yes, we've seen one.
Okay. Can you tell us about the conversation or what interaction you had with them on Friday?
We asked if they would like to have a supervised visit at a counselor's office in Oxford that would be a neutral location for both parties.
And what happened?
They declined that.
Can you tell us about what the conversation where they declined that?
Yes, they stated that they wanted
Objection.
to at the rec center.
That's personal knowledge. Did she speak to us?
Judge, I'll clarify. Were you present in the room for the conversation?
I was.
Was it on speakerphone?
It was.
Were you able to hear the conversation?
Yes.
Can you tell us what the parent said?
Yes.
Tell us.
Mr. Holm stated that they did not agree to that. They wanted to do it at a public location, the rec center, in Heflin, unsupervised.
Was the department able to agree with that?
No.
Did the department, you said that what the services the department was providing, so the department provided transportation, you said,
Yes.
and gas vouchers.
Mhm.
Did you, is that yes?
Yes.
Okay. Did you arrange for a psych evaluation?
Yes.
And where was that at?
Lucille Bodenheimer in Anniston.
Okay. Did the parents complete the psych evaluation?
No.
You arranged, I've got intake on here. I'm sorry, you arranged for a mental health intake?
No. It was Mr. Holm's responsibility to do an intake with mental health.
Okay. Did he do that to your knowledge?
He did.
Okay. And did he appear for that visit?
No.
Mr. Holm had in fact scheduled a visit though with mental health, correct?
Yes.
He just did not appear for it. Was that correct?
May I elaborate?
Sure.
Mr. Holm did do the intake.
Okay.
He scheduled a day, but mental health called him and canceled the appointment. They then rescheduled, and then Mr. Holm called and canceled that appointment that was rescheduled.
Has he, to your knowledge, has he rescheduled an appointment with mental health?
No.
Has he made any statements regarding his future intent to comply with that?
He stated that he doesn't need to do that. It's not necessary.
Oh, during any of your conversations with the parents, did the name of the child ever come up?
Yes, on October 26th, before the visit began, Mr. and Miss Holland stated they had something to tell me. I'm just paraphrasing, I don't remember the whole conversation. But Miss Holland stated that they had decided to name the baby Malachi, and she even went on to tell me how she'd want to spell it.
Do you remember how she spelled it?
Yes, Malakhi, with no middle name.
While you've had this case, has the child been to the doctor?
Yes.
To your knowledge, has he received any vaccinations?
No.
Have you had specific directions to the doctor's office regarding that?
No. No, I signed a form on the, it was the 2-day wellness screen and on the 1-month wellness screen stating that no vaccinations for baby boy Holm.
Now, you testified that mom was breastfeeding. Is mom currently breastfeeding?
No.
Did there come an occasion where, well, I'm sorry. When the case first began, was mom sending breast milk to the agency?
Yes.
Did there come a time where that stopped?
Yes.
When did that occur?
November 14th.
Okay. And did the parents state why they were no longer going to send breast milk?
No, because we gave them an opportunity. We were giving them an opportunity to bring that. We would deliver that to the foster parent to give to the baby.
Okay. Did they tell you why they were no longer going to bring it to you?
No.
Up and through today, if the parents had brought breast milk, would you have ensured that it got to the foster parent?
Yes, I would personally take the milk to the foster parent.
When breast milk was being brought, what was your what did you do with it?
They would bring it before the visit, and they would either give it to me to put in the refrigerator, they'd take it to the refrigerator themselves, or they'd give it to Miss Cash, the foster mother.
If they put it in the refrigerator, would Miss Cash, the foster parent, get it and take it with her?
Sometimes in the visit we would forget, so I would take it to the foster parent after the visit.
Okay. And currently the child does not have a social security number, correct?
Correct.
Does not have a birth certificate, correct?
That's correct.
So that is in line with respecting the parent's belief, correct?
Yes.
Judge, I don't believe I have any other questions.
Handling.
Yep, I'm sorry, Mr. Holm. Go ahead.
Yes, okay. Which one's this? How long's it gonna be? Already had that. Okay. You'll have to excuse me. I'm getting a cold as well. So, all right. Can you tell us your very first involvement of our case?
Yes, on October 12th.
Okay. Can you tell us what were you told to do?
I was told to go to RMC in Anniston to pick up baby boy Holm.
Okay. That was your first acknowledgement of it.
Yes.
Who asked you to do that? Who told you to do that?
Supervision.
Who had supervision?
Leslie Smith.
Okay. And who were you with at the hospital?
I was with the foster parent.
With the foster parents after our child had been taken?
Objection as to the characterization. Taken.
After our child had been kidnapped?
Judge, I'll object to that. That's a legal conclusion.
After our child had been stolen?
Judge, again, I object to that.
Give the judge an opportunity.
I think it would be fair to say, and I understand where the Holms are coming from, was after the child was removed. Is that a fair characterization, Mr. Holm?
We like the definition of kidnapped.
And Judge, I stand on my objection.
But we will go with
I
it.
understand where you...
Okay.
I understand.
All right, remove. So, were you given a pickup order to pick up our child?
No.
So you don't have to have a pickup order to go and pick up the child?
I'm the foster care worker, which means that has already been taken care of before I even get involved with the case.
So whenever you go to the hospital, do you have to show the hospital a pickup order to pick up our child?
No, that's the investigator who does that.
So you don't have to verify of any type of pickup order at the hospital?
No.
So you need no verification whatsoever to go to another organization to then pick up somebody else's child?
Judge, I won't object. This is basically asked and answered, and it's also cumulative.
Sustained.
Let me just ask that. Okay. Are you not required by law and or policy to show anything? Or to
Objection.
see anything?
Objection asked and answered.
I didn't say law. I said law. Are you required by law?
I'm not really understanding. When I get to the hospital, I show them my badge so they know who I am
Okay.
in order to
But
get
are
the
you not
child.
required by law to have something to present to the hospital to pick up our child?
And Judge, I won't object because I believe the testimony of the last witness has already established the fact that there was a pickup order.
Sustained.
Can you tell us what evidence you had that our baby was abused?
I don't have any evidence of him being abused. The fact that there's inadequate
Just ask and
shelter.
answer. Just ask and answer.
Judge, I would object. I believe she was still answering the question.
You may continue to answer the question as it was propounded.
Okay.
Okay. Inadequate shelter. The fact that you have untreated mental illness. And the fact that Ms. Holm obviously lacks protective capacities because she's going along with what you're doing, such as signing a 30-plus page document with her blood and sending it to the agency and others.
Is that against the law?
It is.
It is against the law.
To put your blood in a document, it is.
Can you what law?
Objection, Judge. She's not up there as an expert in law.
If she's going to speak about the law and knowing the law, she had better know the law.
Judge, if she's going to ask a question that asks her to, is it illegal, she's answered the question. It is not her responsibility to provide the law to support her proposition when that's his question.
Sustained.
Can you tell us who has told you that that is breaking the law?
No.
So it was in your opinion that it was breaking the law?
Judge, I won't object because I believe actually the question is probably eliciting attorney-client conversation.
I think if she had a separate opinion that she can testify to, that she may have drawn on her own, but obviously if you drew that conclusion from a conversation with counsel, and I don't know where your thought process or where you drew that conclusion from is. And you've already testified, no, you don't know. You don't recall. So, to me, it's asked and answered.
Well, she's testified that she's stating the law. I'm trying to figure out, is it an opinion or was it given to her? And that was not testified to yet.
And Judge, it's been asked and answered. She stated she does not recall where it came from.
All right. Can you tell us what evidence you had that our baby was neglected?
Objection, Judge. This is asked and answered and cumulative. It's the same. It is substantially the same question as the last one they asked with regard to evidence.
Abuse is the same as neglected?
It's a different question. You may answer.
The fact that you have untreated illness and the fact that the baby's a newborn and vulnerable.
So that means that, so that's your evidence of saying that the child was neglected?
Objection, argumentative.
All right, that's good.
If there's further that you, I'm going to overrule that for right now because were you finished with your answer?
Yes.
Okay. I can't see you. You're so short. Sorry. And I'm short. So.
Can you tell us what evidence you had that there was an emergency?
Yes. You and Miss Holm did not have a place to live. You have inadequate shelter. You had untreated mental illness. And at the time, we were trying to help you.
Okay. Can you tell us what law we were breaking?
Judge, I won't object. It calls for a legal conclusion.
Sustained.
Can you tell us what you're basing your opinion off for your evidence? What law it comes from?
Judge, again, I want to object. I don't believe that she's been qualified as an expert in the law. She's a fact witness, not a legal expert.
So then it's fair to say that your opinions are...
Is that a question to the worker or a response to Mr. Schlinker's objection?
I was saying to the worker.
Okay, so I'm going to sustain your objection and go ahead and ask your question. I'm sorry, I didn't mean to interrupt. I just needed to make sure.
Okay, I'm
Okay.
sorry too. All right.
It's okay.
So is it fair to say that your opinions have no meaning?
Objection. It's argumentative. It also mischaracterizes the evidence.
Any response to that, Mr. Holm?
Well, yes, because to have meaning, there has to be some type of basis behind it, and we're trying to find that basis, and we're not finding it.
And Judge, she's also testified as to her concerns. There is a basis. She's testified to that basis. She's given that basis now 3 or 4 times.
Yeah, but through those concerns, we're trying to find out about her opinions, and he keeps going back and forth. That's all he's doing.
Judge, I object as to Mr. Holm commenting on my objections. His comments about that be stricken.
Well, okay.
Oh, boy.
I think that Ms. Martin, in her capacity, can give her opinion as to why she picked up this child, the child continued in foster care, I guess, your concerns. I'm sorry, I got you confused with Ms. Jackson. Now, whether or not your answer changes with continued questions, it may or may not happen. But as long as the questions are somewhat different in nature, we'll just take them one by one. Okay, go ahead, Mr.
All
Holm.
right, let me see. Can you tell us what evidence you had that we were unable or unwilling to care for our child?
You have not gave the department an address so we can come and assess your home to see if it's appropriate and if you have provisions for the baby.
Okay, now what gives you the right to have that opinion of that not being the correct things to have?
It's not an opinion, it's a fact.
Okay. All right, listen here. Listen me up. Okay. What about that? see where, all right, so we're speaking of, at the time of the removal of the child? At the time of the removal of the child, what evidence did you have?
Judge, I object she was not the removal worker. That worker has already testified.
Sustained.
Okay, well, that's not, all right, let's see.
As to at the time of the removal, yes.
All right, now we need, right there. This is, I'd like to introduce this. I'm not sure exactly how to. I'm learning.
It's all right. Okay. It's been marked as parents number 6, and that is a newborn identification, I believe.
Yes,
So just
ma'am.
so I can put it down here.
Yes, ma'am.
All right.
Thank you, Mr. Kirby.
Okay. Do you recognize this document?
I do.
Okay. Could you tell us about that document?
Yes, when I went to the hospital, this was the discharge papers.
Okay. Could you tell us whose signature that is?
Yes, it's my signature.
Okay. And can you tell us what it states right underneath it?
Yes, signature of mother.
Okay. Are you the mother?
No, but at the time I was the guardian.
Okay.
Since the state held custody.
Okay. But where was that proof at whenever you went in there for showing the hospital that you were the guardian?
Judge, I'm going to object. This is argumentative. Actually, Judge, I'm going to withdraw my objection.
Okay, go ahead. Answer if you can.
What was the question again?
Where was the proof showing whenever you went to the hospital to sign for that you were the guardian?
My badge.
Your badge.
Yes, stating that I'm a DHR worker with Cleveland County DHR.
So no paperwork.
No.
Okay. I'm not through just yet. Okay. Could you tell us whose name is that right there? Next to yours.
The nurse.
That's the nurse. Okay. Could you read what I certify, please?
I certify that during the discharge procedure I received my baby, examined it, determined that it was mine. I checked the identiband parts set on the baby and on me and found that they were identically numbered.
Okay. So did you have a band on you?
No.
All right. So you were certifying that you had a band on you, but you didn't have a band on you.
Sure.
Okay. I'm not through just yet. Okay. Is that your fingerprint?
I do not recall.
You want to think about it longer?
I mean, I don't remember.
You don't know?
Objection is to me.
Okay. Is that your child's footprints?
No.
No. Okay. So, is this your name up here at the top of this page?
No.
Could you please read that name?
Danielle Holm.
Okay, so it's not your name at the top of the page, it's not your footprints, we're not sure about your fingerprints, and you've certified that you are the mother. Alright.
Judge, I object unless there's a question. That was a statement.
Alright, let me see.
Sustained, you'll have to ask her questions, okay?
I move to
Okay.
strike the statement.
So noted.
Alright. I'm trying to make sure that's it with this. Alright, so is it fair to say the information on this document from what you have put is false?
No.
But we have just stated that you put information in spots that were asking for the mother and not you.
Judge, I believe she testified that she signed because she was the legal custodian as well. Mr. Holm cannot pick and choose what part of the testimony he wants to listen to. So he's mischaracterizing the statement, the testimony.
Okay, okay, I need to, can I admit this, please?
Any objection?
Mr. Kirby, is it part of that other package?
It's part of the baby's hospital records that were admitted into evidence
Okay,
yesterday.
then I have no objection.
So admitted.
Now, concerning the milk, is it fair to say that when a mother doesn't have a child or her baby with her, that the hormonal process can stop the flow of milk?
Judge, I'm going to object. That calls for a medical conclusion.
Okay, are you a mother?
Objection. It's immaterial and irrelevant whether she's a mother.
Sustained.
Okay. Oh, that's irrelevant to me. It's all irrelevant.
Do y'all need to take a minute?
Yes.
We are back on the record on JU 8801. Miss Martin, you remain under oath. Mr. Holm, go ahead.
Were you supervising our visits?
Yes.
All of our visits?
No.
All right, now, do you remember me telling my wife that I would rather her hold our child during the visits because of the nourishment and that the mother needs to bond more with the baby in the beginning stages?
I don't recall.
Didn't you just say that you supervise the visits?
Yes.
Not too much you can learn. Restraining order. Set it right there.
You might want to ask Mr. Kirby to make sure.
Okay, I'm showing you Parents Exhibit number 5. I'm not sure if I need to show it to Mr. Slinker anymore.
I've seen it.
Okay, all right.
I've seen it, so.
Could you tell us what this document is?
It's a restraining order.
Okay, for what?
Regarding you, Miss Holm, and people at the department.
Okay. Could you flip to the back and tell us whose signature is on it? I'm sorry. Maybe it's right. Let's see. Right there.
You want me to read all of them?
Well, do you see your signature on it?
I do.
You do. Could you tell us why you signed that?
Due to the documents that the department received from you and your wife.
I know. Okay, but could you tell me why you felt compelled to come and file that here at the courthouse during this case?
Mr. Holm, in those documents that you gave to the department, you stated demands and threats. The demands were that if you do not receive your child in so many days, that you're going to put liens on our homes, you're going to contact the FBI, and you wanted $1 billion from us. And obviously you hold good to your word because you have contacted the FBI.
Okay, so we need to understand the definition of threat. Can you tell us the definition of threat?
No.
Can you tell us the definition of demand?
No.
So then you really don't even understand the process of a demand or a threat to even go make or file a complaint.
That can be your opinion.
Okay, well, is it not opinionated that you don't even understand the definitions of them?
I'm not going to argue with you.
All right.
That's good.
Here, put that back up. Put that back up here. Okay, you're through asking questions.
I think so, yeah. I know something about that.
Just can I take the witness on what
You may.
Ms. Martin, is it a bit intimidating to have Mr. Holm asking you questions, and not that he's intimidating you directly with the intent of doing that, but is that just a little intimidating to you?
Yes, sir.
Okay. Do you know what the definition of demand is?
Yes.
Can you tell the court what that is?
Something that you want, and you want it right then.
Okay. Do you know what the definition of a threat is?
Yes.
What is it?
Where it makes you just feel very uneasy, such as you're going to be harmed in a certain manner.
Okay. And is that what you were referring to when Mr. Holm was just asking you those questions?
Yes.
Okay. Judge, I have no questions.
Okay.
Okay, go ahead, Mr. Holm.
Was the word demand used in those notices?
Yes.
Was the word threat used in those notices?
No.
Okay. Could you please tell me your education and experience, please?
Yes, I have a bachelor's degree in social work.
And experience?
I've been employed at Cleveland County DHR for 8 months.
Okay. Any other licenses or qualifications?
No.
No. Okay. The visitations that were spoken of about last Friday that you were listening to on the phone call, did we not offer to go meet in another place with Mr. Kirby as supervision?
Yes.
Didn't you make a statement that we refused visitations with supervision?
Our supervision, such as a counselor, a mutual person to do the visit, such as a counselor.
So is Chehaw State Park your counsel?
Chehaw Counseling?
Chehaw Counseling, is that?
No, it's a provider.
So that's someone that's separate from you.
Yes.
So it's not your supervision.
Judge, I don't think she understands the question.
So
I think, and Mr. Holm, maybe I can help you clarify. And correct me if I'm wrong. I take your line of questioning as, is Chehaw Counseling Center under your agency,
yes, ma'am.
and is that within your supervision? Is that where you going?
Yes,
Tell
ma'am.
me where you're going with this.
Yes, ma'am.
Help me understand. Okay.
Yes, that's it.
Okay. All right. So if you want to phrase it that way, or
Is
have you,
Chehaw State Chehaw Mental Health organization under your supervision?
No.
So you just stated that we refused y'all's supervision, right?
I was not present for that phone call with Mr. Kirby when you asked for if Mr. Kirby would like to be, you want Mr. Kirby to supervise the visit. I wasn't present for that phone call.
So you were only present for which phone calls were you present for? Speaking about this visitations. Yeah.
Friday morning, last Friday morning, I was present for the first conversation.
Okay. When we said that we weren't comfortable with the counselor meeting at a separate counselor.
Yes.
Okay. All right. That's fair. Okay, now about with the opinion of Hillary Clinton, is it okay to have a different political opinion?
Yes.
Is it okay to have different beliefs?
Yes.
Okay. No further questions, Your Honor.
Gordian?
Yes. Can you tell us approximately how many visitations the Hollands have with their child?
I'd have to look at a calendar.
Well, I think according to your testimony, they were visiting 3 times a week. And
Yes.
did that occur for several weeks?
Yes.
So fair to say probably at least a month that they were visiting? Is
Yes,
that
ma'am.
fair to say? How many of those visitations were you present for, or did you supervise?
I supervised all of them. I did not supervise each one the entire time. I would, walk away and then come back.
So you have, for your supervision of those visits, you witnessed interactions between the Hollands and the baby.
Yes.
Did you have any concerns with how either of the parents interacted with the child?
It just concerned me that Mr. Holm didn't interact with the baby.
I think Mr. Holm was questioning you a good bit about when you went to pick up the baby at the hospital. When you picked up the baby at the hospital, were you aware if the hospital already had an order?
Yes.
Did you ask them if they had the order? Did you know that they had the order prior to you taking the child?
Yes.
What are the department's current concerns with the Hollands, and specifically relating to having unsupervised visitation?
Because Mr. Holm has untreated mental illness.
And what, I guess, are the current concerns altogether for the Hollands having their child?
Untreated mental illness, and the fact that we do not know, they have not provided us with an address, so I can't assess their home to see if it's appropriate and to see if they have provisions for the baby.
What statements have the Hollands made, if any, about where they're living at the time?
They refused to give us an address, so.
Have you personally asked for an address so you can go and inspect their home?
Yes, ma'am.
And that has been denied to you?
Yes, ma'am.
What, if anything, have either of the Hollands disclosed to you as far as mental health?
None.
I'm sorry.
Said none.
What are your concerns with, I think you testified earlier about protective capacity, specifically of mom. What is your concern with her protective capacity?
Because she seems to be going along with Mr. Holm. For example, her signing the documents with Mr. Holm.
Does the department currently have concerns for the child's safety if the child was placed or given back to the Hollands?
Yes.
Judge, that's all the questions I have.
Hopefully just a few, Judge. Just so we clarify, I think it came out, but I want to be sure that it's clear. So there were 2 phone calls with the Hollands in the department on Friday, correct?
Yes.
And which one were you on?
The first one.
Okay. And you recall approximately what time of the morning that was?
That was before noon.
Now, let me show you what's been marked as Parents Exhibit 6. So you said you signed that, correct?
Yes.
Okay. Are you the mother of that child?
No,
Okay. Why did you sign that?
because the department held custody, so it was guardianship.
Is that part of the discharge protocol of RMC?
Yes.
Do you-
Objection. Does she know the discharge protocol from RMC? RMC? RMC.
Good. Certainly. I'll withdraw that question.
Okay.
On approximately how many occasions have you removed a child from RMC hospital?
9.
So that's your first one?
Yes.
When you were discussing with RMC, is that a document that they told you needed to sign?
Yes.
Okay. So you didn't do that because you're stating you're the mother. You did that because that's what they put in front of you to sign,
Yes.
and that was in the order for the child to be released to you.
Yes.
Now, with regards to Parents Exhibit number 5, you signed that on November 29th, correct?
Yes.
All right. Subsequently, on approximately November 30th, another document was received by the agency. Is that correct?
Yes.
Okay. And is that the one that you referenced that had the blood on it from the mother?
Yes.
And it also had blood from the father?
Yes.
Okay. Did that cause you concern?
Yes.
Personally as well as for the parents?
Yes.
Okay. Specifically going to the concerns then that Mr. Holm was going to with regards to that. You said that...
With regards to what? You said
I'm sorry,
that-
with regards to... Judge, I'm confusing myself.
Okay, I'm sorry, I just got lost there.
With the demands that were made in the first letter, did you feel threatened by those demands?
Yes.
With the demands made in the second letter, did you feel threatened by those demands?
Yes.
With regards to a document being received with blood on it, did you take that as threatening?
Yes.
Did that concern you at least somewhat for your safety?
Yes.
Several questions were asked of you about whether or not you had a order with you when you removed the child. Is it customary for you to be able to rely on the work of a fellow employee?
Yes.
And so if a CAN worker has done something and removed a child, do you rely upon that?
Yes.
Do you go back and reinvent everything, or do you pick it up from where they have it?
Pick it up from where they have
Would
it.
that include would that include them having secured the child through a pickup order
Yes.
and them having executed the pickup order?
Yes.
And they would have made sure that that pickup order was with whoever it needed to be?
Yes.
Has the department made reasonable efforts in this case?
Yes.
Are you asking for a finding of reasonable efforts?
Yes.
And would that be the services that you previously testified to?
Yes.
And what are your recommendations in this case?
That let me start over. That baby boy Holm remain in our custody until the parents can get a psychological evaluation, get treatment for their mental illness, and have adequate housing.
No other questions?
Mr. Holm?
Yeah. Has it ever been ordered for us to go get any type of medical assistance?
Ordered?
Ordered by the courts?
No.
Okay. So then really it was based on our own opinion if we needed to go and do it or not, correct?
I'm not understanding.
You said that as far as your examination, and for keeping the child, it was due to us going and doing a psychological evaluation, only things that were not met, right?
Yes.
Okay. So I'm saying to you that there's no court order that was ever showed that we had to go do that, so how are you justifying that that needs to be right or done?
Due to your actions, we're just concerned the fact that you have untreated mental illness.
So what's your opinion?
No, I believe it's a fact.
Well, you have to. How can you back that up behind facts?
Objection, argumentative.
So that means you'll have to ask a proper question, Mr. Holm.
What actions?
The 3 documents that you have sent to the department, your medical records.
The medical records that you have gotten after you ought to have taken our child.
Yes.
Okay. Now the demand notices. Did these notices recite laws?
Yes.
They did.
Objection, asked and answered.
I don't think we ever spoke about what was on the notice.
Judge, the question was they did. Or,
Did these notices recite laws? They did. Next question.
Okay. Could you tell us what those laws are?
No.
objection, Judge, the documents are in evidence, they can speak for themselves.
Can I get them? Which ones were that? I'm sorry.
This will be on the other side. Should be the dates.
Excuse me. Mr. Kirby, do you need a minute?
Very short.
Okay.
We'll be all right. Ma'am?
Go off the record right now.
Yes, ma'am, that's fine.
Okay. If you hear back on the record on JU 8801, Ms. Martin, you remain under oath. And Mr. Holm, go ahead.
Okay.
Open show.
I would like to show our State Exhibit 2.
Okay.
I believe. Is this the notice where we have already stated that it had demands but no words of threat?
Okay.
Okay, could you tell us the date on the...
November 8th.
All right, could you tell us when y'all received the notices?
I do not recall.
Was it on or around about the time around that time of that date?
Yes.
Okay. Could you tell us what this is?
The 3rd document you sent?
Yes. All right. Now,
And just for the record, what exhibit number are you referring to, Mr. Holm? Just so I'll know.
it's Exhibit 3.
Okay, exhibit 3.
Yes.
Thank you. I'm sorry.
All right. Now, could you tell us the date when visitations were taken away?
November. Reword your quote. Can you reword?
Could you tell us the date that our visitations were taken away? Because of the notices.
I don't believe they were taken away. To my knowledge, you and your wife stated that you did not feel safe at the department on
Okay.
November 14th.
That was the first day. But the day that we came in and there was officers that were called to y'all's organization, to the DHR department.
I was not present.
Okay. Now, you had stated that the visitations were taken away because of fear or threats, because of threats of a blood document. Are you aware that the blood document was not even in y'all's possession at the time of whenever the visitations were taken away?
Yes.
But you stated that you felt threatened by the blood documents and they weren't even there at the time.
And
It's not-
Judge, that mischaracter, he's attempting to say that on November whatever day where visitation is suspended, that document existed, and that was not what her question, that was not the question I asked her. I asked her after they received it if she felt threatened by the blood document as well as the other long page document that they received that day. So it's a mischaracterization of the testimony.
Sustained, but if you want to go further into that, you may want to break your question down to piece by piece by piece, okay? Hang on to it, just don't leave with it.
Okay.
All right, so we've already got, the date was around the 8th of November on this one.
Yes.
And that is, this one is?
This is the exhibit.
Number 2.
Number 2.
Okay.
And the date whenever visitations were stopped, what date was that?
Judge, objection, asked and answered, we've been through the dates.
Can you refresh my memory?
Judge, it's not the witness's responsibility to refresh counsel's memory.
It has been asked and answered.
Okay.
And
Now, did we find out if this date of this document of exhibit or stage 3, if that was after the visitations have stopped?
Yes.
They were? Okay. Where do you want these at?
just put them. Thank you.
When you were observing our visitations, did you see us napping together on the couch
Yes.
with our child?
Yes.
Who was holding our child?
Miss Holm.
Who was holding Miss Holm?
Miss Holm was, when she napped, she was either in the chair or she was curled up on the love seat or the couch.
So you never saw me next to her holding her as she's holding our child?
No.
So then where was I? In the room.
You would be like sitting on the couch. I mean, I've seen you with your ball cap covering your eyes, napping, sitting straight up.
That's one of the times. Yeah.
Objection, counsel's testifying. Ms.
So,
Strunk.
So stricken?
All right.
Okay.
So have you ever seen me holding my wife?
No.
Excuse me.
Is it mandatory for anybody to hold anybody?
Objection as to the broadness of that question.
Okay. Mr. Holm, if you can narrow that down a bit, that was a bit broad. I'm not sure where.
Yeah, I think I'm trying to get to getting something out, but the truth, but it's just not happening properly. So I think I'm just going to stop asking questions and just.
Well, I mean,
Yeah.
that's certainly within your purview if you want
Yeah.
to. I mean,
The truth
If
is
it-
hard to get to, is all I'm trying to say. That's all I can say. So, all right.
do you need a minute with Mr. Kirby, or you?
No, ma'am.
Okay. All right. Do you have any other questions for Miss Martin?
No, ma'am.
You sure?
I'm sure.
Okay. Guardian?
No questions.
Judge, I had forgotten one very, very brief line, and I apologize. I should have already taken care of this. Let me show you what's been marked as State's Exhibit 6.
Okay.
Let me show you what's been marked as State's Exhibit 6. Do you recognize?
Objection. That's not admitted.
He can ask about it.
Okay. Let's see where he's going with this. as to whether or not he's trying to admit it or what he's trying to do with it.
Do you, can you tell us who is in exhibit number 6?
Mr. Holm.
And did you have occasions to see Mr. Holm in that condition?
Yes.
And does that fairly and accurately represent Mr. Holm at the times that you would see him on the streets of Heflin?
Yes.
Judge, we would offer exhibit number 6.
Object.
Brown?
Objection. Not properly, what? Authenticated.
Judge, there's been a proper authentication. Need not be the person who actually took the picture, just need to fairly and accurately represent the image as it was by, and someone has to have the knowledge that it fairly and accurately represents it. She has so testified.
Anything further, Mr. Holland?
Did she take this picture?
Are you asking a question, or is that...
I'm saying, is she the one that is she the one, is she the person that took the picture?
Judge, I don't believe he's got the opportunity to ask questions right now unless you want to take the witness on board. But I would say that whether she took the picture or not is immaterial to its admissibility. The question is whether or not it fairly and accurately represents a particular time in place that she has seen it, and that she can testify to that looks as it was on the times where she saw a person in a particular place. She need not be the actual taker of the photograph. There is no requirement that you have to have the same person who took the photograph present.
Then where is the other person that took the photograph, and what time and what place does she
Okay,
have?
you'll have to ask that in the form of a question. Right now I'm dealing... Are you wanting to take Miss Martin and ask her a few more
No.
questions?
To be honest with you, I don't like all these questions.
All right, my admit, state 6, it's picture.
I think I would like to state that I am a man and my wife is a woman under our Creator, and we demand our child back. And we have not broken any laws here.
And Judge, I won't object to counsel making statements on the record.
Okay. So noted, we need to go on with the questioning of this particular witness. Is there...
And at this time, Judge, the state has no more questions.
Of Miss Martin, okay.
Correct.
Anything else, any other questions for Miss Martin, Mr. Hall?
No, ma'am.
Okay.
No
Ms. Miller?
questions, Your Honor.
Okay. May she be excused.
Please. State rest.
All right. Mr. Curry?
You want me to speak for you?
That's fine.
At this point, in the case, we'd ask that the state's petition for dependency be dismissed on, although it was quite confusing, but it was a lack of evidence that there was an emergency situation at the hospital that required...
Let me stop you right
Okay.
there. Is this the same motion to dismiss that Mr. Holm was going to bring up, or is it a separate motion?
Same motion. No, that's got to be set for a different hearing. The motion to dismiss the petition. Got to be set. This would be your motion just to dismiss the case. Is that the way you understand?
Yeah, I mean, Mr. Holm argued it, and then at the beginning of the case, or at the beginning of this portion of the case, yesterday, and I believe I said it wasn't right for adjudication at this time.
I think something said it was premature.
It was premature. But however, if you wanted to raise that at the appropriate time, you could do so.
Is now the time?
Well, I can't give you legal advice. I'm just trying to discern if Mr. Kirby's making a separate motion or if he's continuing on your motion. Because if he's continuing on your motion, you've got to make the argument. If he's making a separate argument, then he can do that.
Well,
Okay.
go ahead and argue your motion.
Okay, now's the time.
Do you need a few minutes?
To dismiss the case on lack of evidence.
Okay.
The state hasn't given any or proven child endangerment and/or an emergency. We've had.
Slow down for me. I'm writing it down, okay?
Yes, ma'am.
State, okay, go ahead, get.
The state hasn't proven any child endangerment and/or emergency. They've given observations, but no physical evidence. I think that most of their witnesses also stated at the end of their testimonies that there was no emergency and/or child endangerment. And we only have observations from social workers, opinions, and that's it. And we love our child and we miss him and we need him back. And we have everything needed. Shelter, any of the necessities to provide.
Anything else, Mr.
Let me,
Moore? Need a minute?
let me ask if the state would object to Mrs. Holm reading a statement in support of their dismissal.
I would, Judge, because that would be Ms. Holm now arguing their motion as well. So, I mean, this is Mr. Holm's motion to make, and
Uh,
he's welcome to make whatever argument he wants to, but
We're actually one.
I don't believe that that would be appropriate. I don't believe that it would be in line with the way courts operate.
Okay.
We see ourselves as one, Your Honor.
Okay.
if you want to read it, it's
Okay, I'll read it.
It would state object to that, to Mr. Holm.
It's his motion. I mean, he can read whatever he wants to. I mean, it's his.
Okay.
This one.
Okay, this is my wife has written this. Today I am not looking at you as a judge, not to disregard your accomplishments at getting sworn in under oath, the oath that you swore to protect, but to look at you as a woman our Creator made in His image and a woman who was given the amazing gift of motherhood, as was I. Today, as woman to woman, obviously I'm not, mother to mother, we are sisters designed and created by our Father. You are a mother of two boys. Our Creator chose you to be the mother of those two boys, just as our Creator chose me to be the mother and Christian the father of our baby boy. Through our sacred bond of marriage under our Creator, we chose together with the Father to create life, and we have committed with the Father to nourish, nurture, and protect not only our baby's life, but all life, for the sake of true unconditional love. This has been ripped away from us unlawfully, unjustly, and ungodly. It has been almost 2 months since we have had our world ripped away from us, our beautiful, healthy baby boy, ripped out of our arms as was given him the nourishment our Creator designed for me to give him from my body, that I was designed specifically for our baby. And for what? A simple case of false identity that was resolved before our baby was even stolen, because it was fabricated event to begin with. Or was it voluntary enumeration at birth program we refused? Or the refusal to give our baby a name until the right time, which is once again voluntary. The pain I have carried around me as a mother some days has been unbearable. There are nights I have cried myself to sleep while holding a blanket that no longer holds his smell, while Christian holds me as a loving husband, father, and true man of the Father, only to feel my pain, to then wake up the next morning without our family together, feeling empty and in physical pain from the damages every single person sitting in this courtroom today has caused our family. For the last 2 months, our family has been destroyed. For the last 3 weeks, our entire family, especially our innocent baby, have been victims of cruel and unusual punishment with complete separation, completely ripping the bonding or the bond of mother and son apart. All because the actors at DHR are afraid of finally being held accountable for wrongfully destroying families, rather than protecting them. Can anyone here tell me what color our baby's eyes are now? Because we haven't seen them in 3 weeks. Can anyone here tell me what size clothes he is now, or diapers? Because we haven't been able to watch these precious moments of his growth. Can anyone look me and see or feel my pain and actually care? Through it all, with God, each and every day, we find the strength to get up and get ready for our baby to come home to us, and through it all, we pray that through my pain, Christian's pain, and our baby's pain and suffering, that others will find the compassion within and come back to love and ultimately back to our Father. Today we look to the Father and we pray that He inspire you with the truth, for the truth needs no defense, when He is the cornerstone of your entire being. When you walk the walk of the Father and you listen to the inspirations of Him, your paths cannot be made straight again. He is asking you today to come back to who He truly is and to feel the love shining through an innocent, loving couple who have been falsely accused, abused, and beat down by a system that does not know the Father. For if the system knew the Father, we would not be persecuted. Sister to sister and brother to sister, we ask you to find the compassion within you to see and understand the truth. For we have done nothing wrong, neither in the eyes of the law nor the eyes of our Father. Our baby needs his loving parents, and we need our beautiful baby, who is solely our creation, with our Creator, the Father. Judge Melody Walker, will you give us back our baby today without the torture, pain, punishment, interruption, and involvement of anyone in this court ever again?
Is that all argument pretty much?
I guess there would be more depending on what would happen next. Yes.
All the states
So yes, that is.
that's all. Okay.
Mr. Schlinker will get the state the chance to respond in the guardian.
Your Honor, DHR has made a prima facie case of dependency in this case. There is sufficient evidence for it to move on from here. So we would ask that you deny the motion to dismiss and that we proceed.
Guardian, any response to the motion to dismiss by the parent?
Judge, I'm in agreement with the department that there has been evidence presented to support the case.
At this time, I'm going to deny your motion to dismiss. However, you certainly have the opportunity to present your case now. And it's 11:45, so we have an hour and 15 minutes. And you said yesterday, Mr. Kirby, I think you had 6 witnesses.
Well, we've resolved some of those witnesses.
Okay.
Cross on the state's case. That would be Stacy Jackson and Alex Martin. We would need to call Carrie Pollard, and I need a moment to discuss what witnesses that they would like to call on their behalf.
Sure. So I'm just trying to think. How many witnesses, which is what you're fixing to do. If we have to come back, what's everybody's schedule look like Monday afternoon?
Better question.
Can I speak before we agree to?
Yeah.
Or are you just asking the schedule?
Yes. Just
Well,
just
I have a
scheduling
question
purposes.
before we start bringing in more witnesses. So, is our child not being released to us?
Okay, I'm gonna let Mr. Kirby discuss that with you.
Let's go in here.
All right, we're back on the record in JU 88.1. And Mr. Kirby.
Okay, Your Honor. Because we are not residents of this state, and because of religious rights, we're going to have to file an appeal.
Is it, tell her if it's your decision not to call anyone?
And it is our decision to not call any more witnesses.
Okay, so you're not going to be calling the persons that you have under subpoena.
We need to carry
But-
it on.
but we ask that Carrie Pollard be made available for the further motion.
Motion for to dismiss the dependency. That the state needed 5 days to respond.
Okay. I understand. So you're not calling any witnesses on your behalf in your case in chief or in response to the state's case?
That would be correct.
Okay. But in regard to the motion to dismiss that was filed and is still pending, then you need Ms. Pollard.
Yes, and Ms. Paul.
Okay, so she will remain under subpoena for that. And the remainder, who all did you subpoena? You subpoena Ms. Busby?
Yeah, subpoena Miss Busby, Miss Pollard, Miss Jackson, Miss Smith. Yeah,
Ms. Martin, maybe?
Martin.
Yeah.
Alex Martin. That's correct. The only one that I mean, of course, I want Miss Pollard, but I'd like to get Miss Busby's testimony concerning the document she filed. That's
Well, I don't know that that would be appropriate at the motion to dismiss.
no. I'm saying,
And if,
can we not give Miss Busby one witness in on your case, Chief? Or do you want to just quit? What's the document that she created or signed? You want
Are you going to address it?
yeah.
Okay.
I'd like to have Miss Busby testify about one thing, and then if the Holms don't want any more testimony, then that's fine.
so at this time, Mr. and Ms. Holm, you would like to proceed with your rebuttal to the state's case in chief, or your case, I guess, not necessarily rebuttal.
It's only that.
Okay.
Okay, very well.
Is Miss Busby available?
Yeah.
She's waiting right across the hall.
Supposed-
She's texting.
If she's getting her, Mr. Kirby, do not leave. Monday afternoon, can we set that dismissal? Do we, that for hearing, Tuesday afternoon, you're going to be here anyway.
Yeah, Judge, I would say Tuesday afternoon because I'm on leave otherwise.
Mr. Kirby, are you going to be here Tuesday afternoon?
Let's see.
This dependency docket.
Judge, I'm trying to think if I can go ahead and do it now. I just not had a chance to look at the law, so I would like an opportunity to, at least briefly.
Well,
Tuesday afternoon. Oh, well, matter of fact, I will be here that afternoon.
okay. Let me look and see on the docket how stacked we are at certain times, so I can give you a certain time. Are you all throughout the day? Tuesday afternoon?
Yes, ma'am. I mean, I'm going to be here anyway, so I'll use that time to go see people, you know.
You'll make use of your time
I'll make use
wisely,
of my
how's
time.
that? Okay, so we're looking at setting that probably at the end of the docket, Tuesday afternoon, which would probably be 3:30, 4 o'clock.
Okay.
Work with you? Ms. Miller, work with you?
Yes, Your Honor.
DHR, work with y'all? All right, we're still on the record. Ms. Busby, if you'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, you'll have to speak up, okay?
And Ms. Busby, thank you for coming. What, can you give us we got your name, what is your title?
Director,
Director of,
Cleveland County Department of Human Resources.
okay, what are your responsibilities for
Excuse me.
the department?
My responsibilities there are hiring, any personnel actions, kind of general oversee of all the financial and child welfare programs.
Okay. Mrs. Busby, you're represented by counsel, aren't you?
Yes, sir.
Okay, and would that counsel be Mr. Slinker and Mr. Hamlin?
Yes.
Okay. Have you discussed any documents that you filed with this court with Mr. Slinker or Mr. Hamilton? Hamlin, I'm sorry. Hamlin.
Judge Holm, because that's attorney-client, anything that she's discussed with the department?
I'm not asking her
Or
the
the
content
attorney.
I'm not asking her the content of the conversation. I'm just asking her, did she discuss it?
And Judge, anything that she's discussed, whether she's elected to discuss it with her counsel or not, would be privileged, and we would object to her acknowledging any conversations with her client or with her counsel.
Sustained.
Ms. Busby, I'm going to show you what's been entered as Parents Exhibit 5 and ask you if you recognize that document.
I recognize this first part. I don't believe I have seen this back page.
Okay. And this,
Yep.
that was
Judge, for clarification, there's an order attached that Ms. Busby has not seen.
Okay.
Okay.
I was wondering about what that
Right.
was. Go ahead.
All right. Ms. Busby, can you tell the court what this document is?
This is a motion for a temporary restraining order, a preliminary injunction, and final injunction against defendant, asking for a restraining order against filing liens against personal property.
Okay. And Ms. Busby, whose names are on the back of that document, please? Whose names are signed
The
to it?
signatures on this are Marcia Busby, Leslie Smith, Stacy Jackson, and Alexandra Martin.
Okay. And can you identify the other people other than your name on the back?
Yes. Leslie Smith is supervisor of my office. Stacy Jackson and Alexandra Martin are workers.
Okay. Do you know any of them to be attorneys?
No.
Are you an attorney?
No, sir.
Okay. And you are represented by counsel. Is that correct?
Yes.
Okay. Ms. Busby, what was this what was Plaintiff's Exhibit 5 in response to?
That was in response to a large document that I saw that the Holms had mailed out to a lot of places that had a page in the document that stated that liens might be filed against, and it named a lot of employees with the department.
Okay. Did you turn? Let me ask you this: before you filed this, did you verify this with counsel?
I'm not sure I know what you mean by verifying.
Well, did you bring this document over to file at the courthouse, Parents Exhibit 5?
I personally did not bring it. I signed it. I think I was the first person who signed it, and it was going to be filed after all the signatures are complete.
Okay. Do you know who brought this document over to be filed?
I do not know who filed it.
Did you send a copy of this to your counsel?
It was my understanding that they had a copy of it.
And how was that your understanding?
Judge, again, at this point, we've already been through this. I've already represented to the court. It was drafted by counsel for the department. There was an intent for me to put my signature on there. It was an oversight by my part based on a distance issue that the department has, and unfortunately it was a drafting error and therefore then a scrivener's error as well, because the department, it was the intent of legal to sign that document as well. So again, that has already been that's already on the record. I believe it's the same with this witness. I don't think she can testify as to anything that legal has or hasn't done. And again, I think she can again, I think it is clear that we're now being just duplicative of other information because, again, this is the exact same evidence that was involved with Miss Jackson's testimony.
Judge,
Kirby?
and Mr. Slinker testified beautifully to creating this document, but let me ask, well, we'll go ahead and you can, I mean,
Your response to his objection?
I'll move on. I'll withdraw.
Okay.
Okay. Let me ask you, Ms. Busby, I'm sorry. Is your counsel signature on this page, either one of your counsel's signature, any counsel signature, oh, excuse me.
No, it's not.
Okay. That's all I have, Your Honor.
Anything to say?
Ms. Busby, when you signed that document, were you concerned for the safety and welfare of your staff?
Yes,
And was that because of what you perceived to be threats of the Holms?
absolutely.
And is that why, and again, that is the sole purpose of you filing that, correct?
Yes.
No other questions?
Anything further, Mr. Kirby? Oh, wait, I forgot the guardian.
Oh, I'm sorry.
I don't
Sorry.
have any questions, Judge.
What, do you understand what a lien is, Ms. Busby?
Yes.
Do you understand that this is not a civil case about liens and civil suits? This is a dependency case.
Yes.
What is your understanding of a lien?
My understanding is that some documents are filed where a freeze is put on personal property that you could not sell or do any kind of business with that property until the lien was removed.
Okay. And that's a correct understanding. That's good. How would, well, let me ask you, what kind of threat did you take that as? Did you take that as the threat that the Holmes were dangerous to you? Holmes, excuse me? Were dangerous to you and your staff?
I don't know when you say dangerous. I mean, I think as far as if that were something they were able to follow through with, I do think that it could cause some personal injury to, an employee if that were to happen, for them to have to go through some kind of event or expense to get a lien removed.
But are you talking about physical personal injury or?
Not on the lien
Fiscal,
per
I
se,
guess.
but I do think that is a threatening statement. It may not be physical in that particular part, but I do think it's a threatening statement.
Does it threaten a lawsuit?
Objection, Judge, because it assumes facts not in evidence, and it also, the document speaks for itself, and also that Mr. Kirby is leading.
Mr. Kirby?
Judge, the documents are in evidence. I think the demands that the Holmes made on were entered as states 1, 2, and 3. So those documents are in the evidence, and I wasn't leading with the question.
If you recall, those speak to a lawsuit? If you recall.
Can you re-ask me the question you're asking?
Do the demands, is there anything physically threatening in those demands?
When you say physically threatening, if you're talking about physically injuring someone?
Yes, danger to a human, to a person. Were you afraid for your caseworkers' physical safety?
My answer to that is, in some respects, yes, because the thought processes that when I read the document, the thought processes of that document are troubling to me.
Did you read the document?
Yes.
Did you read all of the documents that were submitted by the Holmes?
My recollection is I read 3 pretty large documents.
Yes, ma'am. Okay. And did any of those documents contain a physical threat that would cause you concern for your caseworker's physical safety and well-being?
Objection, it's been asked and answered.
Sustained. She has answered that.
Okay. Okay. Judge, I'll pass the witness.
Are you aware of other cases where people have filed liens without having first obtained a lawsuit?
I have heard that has occurred, yes.
And so was that part of your concern?
Yes.
No other questions?
Gordy?
No questions, Judge.
Mr. Kirby?
To your knowledge, has there been any liens filed?
Not to my knowledge.
That's all I have.
Okay.
Nothing further?
Gordy?
Nothing, Your
May
Honor.
Ms. Busby be excused.
Please.
Yes, ma'am.
Mr. Kirby, anything else on behalf of the parents?
No, just not anything's on the benefits. You mean like more witnesses?
Yeah.
No.
No witnesses.
I mean, you can't like twist their hand and make them tell the truth, so. You have to go higher. What laws have we broken?
Your Honor, I guess the parents' case will rest then.
And Mr. and Ms. Holm, is that indeed your position that you rest at this time? Rest means that you're done.
We're gonna go higher. I don't know what you're trying to, you know.
Well,
what
it's
you're-
done today.
Today.
You're not calling any more witnesses on your behalf.
Yes.
Okay. Thank you for helping me clarify that, Mr. Kirby. All right. So I will take this portion of the case under advisement. And before I issue a ruling, I want to hear argument on the last pending motion. And that's the motion to dismiss that was filed Monday afternoon.
Yes, ma'am.
Just today is Wednesday, okay. Are there any other pending motions that have not been resolved that you're aware of, Mr. Kirby?
I can't think of any. The only, no, there's no pending motions that we have right now. Anything that you guys can think of?
No, Judge, I don't know of any other motions that are pending, so I think, other than that one, so I think we're at a done stage with that.
Okay, I think so. Guardian, can you think of any pending motions that are filed with the court?
I don't believe so, Your Honor, except for the one that is set on Tuesday.
Okay, because I think, yeah,
I guess the only issue we have now is visitation.
well,
Get it started back as quickly as possible.
And Judge, I believe after talking with the department and kind of talking about that yesterday, I believe there is going to be a visitation today.
Okay.
Is that correct?
Yes, we have arranged for there to be a visitation from 3 to 3:45. The Sheriff's Department has agreed to be present.
3 to 3:45.
Judge, we asked what time they could give us an officer, and that's the most they said they could allot to us.
well, it's a start. And I will take the case under advisement until Tuesday afternoon. We're adjourned. All right, we're here on JU 8801 in the matter of baby John Doe. Mr. Kirby, you said we needed a moment.
We do, Your Honor. I think that Mr. and Ms. Holm wanted to have on the record that they were here for the hearing that was set this afternoon.
Mm-hmm.
And Mr. Holm wanted to make maybe both wanted to make a statement on it, but
We would like to ask if we could have our child back, please.
We miss our child.
You've done nothing wrong.
We love our child, and we've done nothing wrong. We haven't broken any laws.
We have everything that's needed for him. We have for the last 2 months. There's no need for this.
Let me stop you right here. I very much understand your position. However, today filed, I guess, as a courtesy copy through this case number was what is purported to be a federal lawsuit filed in the Northern District, I believe, of so it has a filed stamp copy on it against the State of Alabama Attorney General, and it names me very much so and predominantly within the body of that 71 pages. As such, I've discussed with my presiding judge per protocol and have entered an order of recusal. I can take no further action on your behalf or on your child's behalf or on the state's behalf. At this point, it will have to be assigned to an alternate judge. I'm sorry. Adjourn.